Hi, my name is David P. Shapiro. I am the owner and managing partner of the law office of David P. Shapiro, located in San Diego, California, where my firm helps good people regain control of their future when charged with a crime. In this video, I want to talk to you about SB 145. SB 145 was signed into law prospectively for January of 2021 by Governor Newsom in California in early September 2020. And there have been few bills related to criminal law in modern time here in California that have really achieved or obtained such national recognition, such national controversy, such national division as it relates to SB 145. And the primary reason is because it has to do with sex offender registration. What seems like since the beginning of time in California, statutory rape, with just a few minor exceptions, is a discretionary registrable offense. What that means is California has a sex offender registry. So for most sex offenses, if you're convicted, you have to register as a sex offender. Statutory rape are situations where it's consensual sex with someone under the age of 18 and someone over the age of 18, right? Still illegal, still punishable by time in either state prison or county jail for several years, depending on the specifics of the alleged offense. But regular vaginal intercourse statutory rape in California has not been a mandatory registrable offense in quite some time. SB 145 sought to remedy situations of oral sex, consensual sex between a minor and someone over the age of 18 within 10 years. And they also sought to remedy anal sex or sodomy. Because what you have is you have situations where why is someone who's having vaginal intercourse, let's say a 19-year-old with a 17-year-old, they don't have to register. That's discretionary registration. But you have a 19-year-old and a 17-year-old, let's say, two men or two young men, and then it's mandatory registration for sodomy on a minor, whether it's consensual or not. It's mandatory registration if it's oral sex, oral copulation on a minor over the age of 14, certainly under the age of 14. So California tried to get some equality in the law. Now, you may have an opinion on, well, you should register anyway, even if it's a regular statutory rape case. That's fine. That's your opinion. But let's just be clear on what SB 145 does and what SB 145 doesn't. It just creates equality in the law. It doesn't legalize anything. It doesn't condone any type of behavior, inappropriate behavior with a minor. And it certainly doesn't get people off the hook from registering with any sexual conduct with someone under the age of 14, because those are mandatory registrable offenses in the state of California. So I hope this video has given you some context about really what SB 145 does and what it doesn't. It's an 8-page document. You could certainly look it up and read it. It's pretty well written, pretty easy to digest. And what's most telling about SB 145 is this is not this, extreme left-wing California fanatical type bill. I mean, this is something that's endorsed by district attorneys. This is something that's endorsed by law enforcement. So, when you look back and you peel back all the comments and the social media and the hot takes on SB 145 and really look at what it does and what it doesn't do, you realize that someone could still register as a sex offender even in those situations if a judge wants them to. It just makes things a little more equal under the law, whether you agree with that or not. That's really all that it does. So if you have any other questions about SB 145 or anything related to sex offender law in the state of California, please feel free to give my firm a call at 619-916-4265.